Welcome to the 25th episode of Certum Group's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar from top law firms, companies, and legal institutions across the country. On this program, we discuss the latest litigation trends and strategies across a wide spectrum of commercial litigation, especially class action litigation. I'm your host, Kevin Strzalski, a lawyer and director with the litigation consulting firm Certum Group, where we specialize in working with businesses and their outside counsel to mitigate, cap, and transfer litigation outcome risk through our suite of litigation, insurance, and legal finance solutions. Today, I am very pleased to be joined by Jennifer Riley, Vice Chair of Duane Morris's Class Action Group, where she regularly defends companies faced with significant, complex litigation matters. Jennifer is also a regular speaker, author, and presenter on class action issues, including serving as general editor of Duane Morris's Class Action Review, which is the topic of the show today. Hi, Jennifer. Thank you so much for being on the program.
Hi, Kevin. Thank you so much for having me.
Of course. So now, Jennifer, the Duane Morris's Class Action Review is a 650-page comprehensive analysis of all of the litigation trends and significant rulings, hundreds of rulings and settlements that took place in 2023. I have to ask you to start, what was the motivation behind taking on such an endeavor and putting together this comprehensive one-of-a-kind publication?
So we've been putting together a similar publication for more than a decade. And during that time, we've seen class action litigation grow, both in size, in terms of the numbers of filings, the sizes of the cases, and in complexity. Skilled members of the plaintiff's bar have continued to migrate into the space and to continue to focus their practice on class action litigation, really magnifying the risk and expanding the potential outcomes that companies have to anticipate and deal with. As a result, we wanted to prepare a comprehensive guide, a practical desk reference, if you will, for corporate counsel defending these types of cases. Essentially, we wanted to create a tool that would help corporate counsel as well as business decision makers identify the risks and help them shape their defense strategies. This latest edition, the 2024 Duane Morris Class Action Review, offers 23 chapters, 5 appendices, each of which provides a rundown of the trends, the key decisions, and the key settlements that inform both the current state of play and what we can expect in 2024 and beyond.
It truly is a one-of-a-kind publication, and I think that the firm did an excellent job at really seeing a hole in the market given the proliferation of class action litigation and filling it with what is essentially a desk reference guide for in-house counsel and their attorneys as well. But I have to ask you, you're a practice group leader, you're practicing law full-time, and you and your colleague Gerald Batman wrote a 650-page book. Just tell me about some of the challenges and the juggles you had to do to complete this project. And I'm sure you weren't alone. So tell us about the Duane Morris teamwork and collaboration that was required to pull this project together.
Well, honestly, I eat, sleep, and breathe class actions pretty much 24/7. Each morning, I read the class action decisions from courts across the country. Each afternoon, I review class action case filings in courts across the country. All day long, I develop strategies to defend a docket of class action complaints. So in other words, this publication is more of a natural extension of what I do every day. That said, this publication reflects the great breadth of class action knowledge and experience of the Duane Morris attorneys across the firm. The 2024 book features contributions by 39 different partners, special counsel, and associates with various areas of substantive expertise. So I think it really represents and reflects a team effort.
That's terrific. And as you mentioned, there's so many chapters, there's so many appendices and everything. I noticed in reviewing the book that it really does cover about 10 overarching trends. It really synthesizes things down in like the 10 top topics. Unfortunately, we don't have time to go through all of them. So I just selected 3 or 4 that I would like to review with you today. And the first one is that class action filings continue to spike at an unprecedented level. Now, I've read some surveys and some studies, and I've been in this space, not as long as you, but quite a few years. And I believe statistics show that they have been trending upward. Every year since like really 2017 is when we've seen this boom. Why are we seeing such a proliferation of class action litigation?
In my mind, to put it simply, success begets copycats. So in 2022, for instance, we observed some of the highest class action settlement values we've ever seen, including 14 class actions that resolved for more than $1 billion each. In 2023, that trend continued. Parties agreed to resolve more than 10 more class actions for $1 billion or more. So this combined makes $24 billion settlements in 2 years. That marks one of the most extensive transfers of wealth we have seen in the American court system. And I think numbers like this really incentivize the plaintiff's class action bar to be equally, if not more aggressive, both with their case filings and with their settlement positions.
That is an enormous, enormous transfer of wealth. Now, those are some of the largest settlements that we've seen in class action history. Is there also a correlation between size and the number of settlements compared with the volume of filing?
Well, I think the trend that we're seeing, is in the values of the settlements, which in turn then are feeding the numbers of filings and the size of the classes and the claims that we're seeing come from the plaintiff side in terms of what we're seeing filed across the country.
I think that makes complete sense now. Are we seeing them in certain particular areas, both in terms of the settlements and the filings? Like, what are the real hot areas, the natures of suit that the plaintiffs' bar are gravitating to?
In terms of the filings, we've really seen tremendous growth year over year in the privacy space. So privacy class actions, as well as data breach class actions, continue to generate huge numbers, not to mention wage and hour litigation, which continues to be particularly hot, especially in California, as we're seeing a lot of filings under that California PAGA statute.
Now, wage and hour, I know, has been the biggest area of class action litigation for a number of years, but that's been pretty consistent for many years now. I want to actually focus on the two other areas that you mentioned, because as I travel around and most of our clients are AM Law 200 law firms, I am hearing the two other areas that you just mentioned being top of mind on almost every meeting I have. So let's dive into that. Starting with data breaches. Data breach class action continued to grow, and it grew at unprecedented levels. We track dockets. I know your firm tracks dockets, and you have an excellent team that does so. And they're, behind the publication as well. We're seeing 1 to 3 new filings a day, and this has been going on for a while. Why are we seeing so many? And when I'm talking to lawyers, they're also saying they counsel their clients in compliance programs. What's going on? Why are we seeing so many of these continue every single day?
Yeah, great question. First, I agree with you completely. The volume of the data breach class actions we have seen really exploded in 2023 in particular, making it one of the fastest growing areas that we identified over the past year. These days, I think after every major and probably not so major data breach, we're seeing negative publicity, and then we're seeing that negative publicity prompt these class action filings often across multiple jurisdictions at the same time. So in terms of the numbers, plaintiffs filed about 250 data breach class actions in 2022 in federal courts, and they filed that same number in the first half of 2023 alone, and then filed nearly twice that number during the second half of the year. So I think that several factors are probably contributing to the growth. I think the shift to remote work, the rise of cloud-based storage, the escalation of really sophisticated cyber criminal activity, those things have really threatened data security like we have not seen before. And that gives rise, I think, to more of these large-scale data breaches, which in turn are contributing to these class action filings. And again, success begets copycats. And as plaintiffs are able to monetize these cases, we're seeing them become more and more attractive.
I think you're right. I think one thing you said was really poignant is that the mainstream media is broadcasting these more so now. I think it took a little while for them to catch up and realize how many of these were occurring. We insure claims-made settlements on lawsuits. And so I talk to lawyers all the time about, actual payouts and claim rates. And like 2 years ago, people were saying, the amount that we pay out, it's small and the claims numbers are small, and it keeps ticking up and up and up as more people are aware and more people are, I think, working from home and paying more attention to the news and security with like remote technology and things like that. Now, is another reason perhaps the lack of defenses? I mean, if you have a breach, you have a breach and you have to notify people. I mean, does that also, along with copycatting, is lack of meritorious defenses also an issue?
That's a great question. There are some really good defenses that are working very well in the data breach cases in particular. One of those is the standing requirement. So the U.S. Supreme Court decided a case in 2021 called TransUnion versus Ramirez, where it held that a plaintiff must have actually suffered a concrete injury in order to have standing to maintain a claim. So that concept remains a key defense to data breach claims. In a lot of cases, plaintiffs are able to get past the motion to dismiss hurdle by alleging that they suffered concrete injuries. But then they face an even greater hurdle, though, at the class certification phase, where they encounter this issue of uninjured class members. For instance, just because a plaintiff suffered an actual injury in terms of his or her information being stolen, that doesn't necessarily mean every member of the putative class suffered that same injury. So that tends to be a big hurdle in these cases that plaintiffs are encountering.
Thank you for that. I think that makes sense. So that definitely would be a great defense to start there with standing. Yes, from a procedural dispositive sense, in terms of like the volume of these cases that are filed and how they're disposed of. I mean, how many of these are really surviving the motion to dismiss phase, going all the way through and getting certified?
So courts, as I mentioned, have disagreed about this application of TransUnion. So more and more plaintiffs are getting past that motion to dismiss phase as courts are reaching different results based on very similar allegations. But those plaintiffs, again, are facing that standing hurdle at the class certification phase, which is more daunting. Over the past year, in terms of looking at the numbers, only about 16% of the class certification decisions issued in the data breach space came out in favor of the plaintiffs. So 16% is a far cry from what we're seeing across the board with class actions. Across the board of all class actions, the success rate on class certification for plaintiffs is about 72%. So it's significantly lower in the data breach space.
Okay, so definitely a much better chance of success defeating the class cert than the motion to dismiss earlier in the case. Unfortunately, though, the business is litigating all the way through that process to get there. How long was the average time frame? Let's say you go through your motion to dismiss and you lose at that stage. From there until getting all the way through and beating class cert, do you have any information like on average? How long does that take?
That's a great question. I think you hit the nail on the head there, though, in terms of these cases are still getting filed, meaning that most of them are not getting to the class certification phase, and most of them are settling early. I think as the plaintiffs' attorneys are looking to monetize those claims early before devoting a significant investment to litigating these claims. I don't have the time frame offhand, but I suspect anecdotally or based on anecdotal evidence that many of these cases are resolving early on in the first few months after filing.
Yeah, so it's pushing businesses to settle even though they may prevail on the merits later. So, okay. Now, one area that personally I think is going to be maybe even hotter than data breach cases going forward, and you mentioned it earlier, it's privacy. Privacy class actions gaining momentum. They're increasing in number. They're increasing in sophistication. And specifically, I'm talking about BIPA and BIPA, the Biometric Information Privacy Act and the Video Privacy Protection Act. I talk to law firms a lot, and some of them are just starting to ask about these areas. So can you give us a little bit of an overview of BIPA and BIPA and how the plaintiffs' bar are leveraging these statutes to file lawsuits?
I think that those are two prime examples of plaintiffs taking provisions of state and federal privacy laws, anti-surveillance laws, wiretapping laws, and really being creative with those provisions and using them to fuel challenges to novel, new, innovative technologies that the drafters of those laws probably didn't even imagine when they wrote the provisions. So the VIPA is a great example. That is a law that was passed in the 90s. It prohibits a videotape service provider from knowingly disclosing video rental histories of its customers. So it was passed in the 90s during the era of Blockbuster and video cassette tapes. But plaintiffs are using that law to sue companies that maintain videos on their web pages that track the videos that users watch and then share that viewing data with third parties.
Yeah, definitely very interesting. I actually read an article, and I didn't know this, but I think it was Judge Bork who was nominated for the Supreme Court, and somebody found out his videotape rental history, tried to sort of like poke holes in his personal character. And that was the genesis of this. So it's really fascinating that they're leveraging the statutes that have been on the books, but they're applying it to this technology, just like you said, that they didn't even exist at the time these statutes were promulgated. Now, I mentioned, I think that this is going to be a real hot area going forward for a while. Do you have a sense of how prolific the filings, like the BIPA and other privacy filings are today?
Yeah, I think class action lawsuits in this privacy space have, as you mentioned, just been growing exponentially over the past several years. I think it's the technical requirements of compliance coupled with these really stiff statutory penalties under some of the laws, as well as, of course, the fee shifting provisions. I think those things together are really providing a recipe for these increased filings, as well as, of course, for the hefty settlement demands and the settlements themselves that we're seeing in the privacy space.
Now, I want to ask you the same question I asked about data breaches. What are you seeing, or what do you predict in terms of being successful at the motion to dismiss phase versus the class certification phase? And do you also see, because of the statutory penalties and the fee shifting positions, do you see businesses being forced into settlements in between those two phases?
Absolutely. I think that the motion to dismiss phase is in particular very important in these types of cases. Some of these laws, though, it's pretty unsettled in terms of, for instance, BIPA, the Biometric Information Privacy Act, fairly unsettled given that litigation under the law is relatively new, in that even though the law was passed back in 2008, we've really seen most of the case filings from 2017 to the present. So we're still seeing courts weave a patchwork quilt of rulings in terms of how the law is going to be applied and what it protects.
I think that's right. I mean, I pick up bits and pieces from different meetings, and different lawyers who practice in different areas. And I think you're right. It's just unsettled. And I think the conventional wisdom across the market is more to come.
Agreed.
Yeah. Okay. So I wanted to cover one other topic with you, Jennifer. And I was almost hesitant to include this because I think you and I are both from Generation X, I believe. And this is some technology that's developing that I think is being embraced by the younger generations. There's a whole section in the Duane Morris class action review dedicated to this. It is top of mind with everybody. You can't go to the news without reading about it or hearing about it. And that is generative AI. So there's a section in the review that discusses how generative AI is starting to transform class action litigation. First of all, what is generative AI?
That's a great question. I'm not sure I can come up with the Google answer, but in my mind, generative AI is essentially broadly artificial intelligence that's capable of generating text, images, other data that usually in response to prompts by the user.
Now, we keep hearing a lot about like the lawyers and if they should be embracing it, and law firms, and are they embracing it at the same speed at which other industries are embracing it? Do you have a sense of just like how are the plaintiffs and defense bars starting to embrace this technology?
Well, we're certainly hearing about it anecdotally. Examples that are hitting the press of lawyers filing briefs with fake case citations generated by AI. We're hearing these maybe urban myths about companies with databases of case results that are using AI to predict their own litigation success. Certainly the technology has the potential to better inform and better enable lawyers to do more in less time, to synthesize large amounts of data in a very efficient way. And I think we're sort of seeing probably the tip of the iceberg in terms of these anecdotal examples that are making headlines, if you will, right now.
Yeah, I think it's anecdotal, and I definitely kind of like how we concluded the privacy section, a lot more to come in this area. Can you explain, how do you think it's going to be leveraged on class action litigation, and what impact will it have?
As you mentioned, we talk about it in the Duane Morris class action review. And there we really talk about two different categories, if you will. First, the potential gains and efficiency. AI has the potential to enable the plaintiff's class action bar to do more with less, essentially allowing them to generate more complaints, file more lawsuits that can be handled by fewer lawyers in less time. I think it definitely has the potential to increase the activity in the class action space. The second category, I think, is that the technology itself is providing the raw material for potential claims, including class action claims. A lot of these are based on allegedly false statements regarding the capabilities of AI, which are really providing fuel for those consumer fraud claims. Some of the cases are arising out of companies that are using AI to streamline their decision making, such as insurers who are using algorithms to adjudicate claims, employers using AI to screen candidates. Those types of activities are facing claims, whether on the unfair competition or the discrimination front. And then I think as a third category, the developers of the AI tools and the AI products have faced a swell of class action filings from individuals alleging privacy violations and copyright violations as well, relative to how the developers are using data, collecting and using data to train that AI software.
That is very interesting, especially since we started the program talking about the increase in the volume of filings. And here we're going to conclude the program with a discussion on how AI is going to continue to contribute to the increase in class action lawsuits, new natures of suit, and claims from class members. So I guess it's good for people like you and I to be involved in representing businesses in class action litigation. But we're definitely going to see an evolving area. And to your point, I think AI is going to contribute to that continuing proliferation. So very, very interesting. Well, Jennifer, that's really about all the time we have for today. It was a real pleasure having you as my guest. And I want to thank you for your time and all the valuable insights that you shared with our audience.
Well, thank you so much for having me. It was a pleasure.
Absolutely. Now, if anyone would like to contact you to discuss any of the topics that we covered here today, or if they would like to get a copy of the Duane Morris Class Action Review, how can they do that, and what would be the best way to reach you?
So you can certainly order a hard copy of the Duane Morris Class Action Review by contacting me, jariley@duanemorris.com, or you can go to our website. The book has its own webpage at www.duanemorrisclassactionreview.com. You can also read more about it on our blog, the Class Action Defense blog, which you may find at blogs.duanemorris/classactiondefense.
That's terrific. Thank you again, Jennifer. And of course, as always, I'd like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, Stitcher, or anywhere you listen to your favorite podcasts. And if you'd like to learn about any of the litigation insurance or funding solutions that Certum Group provides, please visit our website at www.certumgroup.com. And you can always reach me directly at kevins@certumgroup.com. Thank you, and until next time.